Welcome to the deep dive. If data privacy often feels like trying to herd digital cats, well, today we're handing you a very practical guidebook. We're plunging headfirst into India's landmark Digital Personal Data Protection Act, or DPDP Act. Specifically, its impact on IT companies, especially those thriving firms in Hyderabad. And look, this isn't just theory anymore. The act officially came into effect back in August 2023. And let me tell you, failing to comply now, it's not just about steep penalties, though those are serious. It can lead to real reputational damage, a swift loss of client trust, particularly with international partners, right? They really prioritize data protection. So our mission in this deep dive is basically to give you a shortcut, a way to understand how to comply, and maybe even how IT companies can turn this into a strategic advantage, all through 5 actionable steps. Okay, let's unpack this.
Yeah, what's really fascinating here is just how quickly IT companies in Hyderabad need to adapt. I mean, given their extensive handling of client and employee data and often those cross-border transfers, it's really not just about ticking a legal box anymore. It's fundamentally about, enhancing data security and really cementing customer trust.
Absolutely.
And that's critical for their sustained growth and resilience in, well, a global market.
That sustained growth is key. So let's establish the foundation. Why is this specific piece of legislation, the DPDP Act, such a game changer, particularly for Hyderabad's IT landscape?
Well, the DPDP Act is India's landmark law governing how businesses process digital personal data. It's a significant shift, really. And Hyderabad's IT firms, they're uniquely affected because, as you know, they process just enormous volumes of data, both client and employee data. Plus, many operate globally, managing those complex cross-border data transfers. That means they absolutely must align with international standards like GDPR. And a crucial point, a good number of these firms will likely be classified as significant data fiduciaries, or SDFs.
STFs, right.
These are entities dealing with high volumes of sensitive data, maybe children's data, things like that, and they face even more stringent requirements under the Act. It adds a pretty significant layer of responsibility.
That SDF classification definitely sounds like it adds a whole new level of scrutiny. Okay, but what are the core principles, the sort of foundational ideas that this law is built upon?
Well, at its core, the DPDP Act actually echoes global standards like GDPR in its foundations. Take consent-driven processing, for instance. But here, it's particularly emphasized that consent must be freely given, informed, and very specific. So, no more vague terms hidden away.
Right.
Then there's purpose limitation and data minimization. This means if you collect, say, a customer's email just for shipping updates, you can't then automatically add them to your marketing list unless you explicitly ask for that purpose too.
Collect only what you need and be clear why.
Exactly. Only take what you need. State the purpose clearly. The Act also enshrines individual rights, empowering people to access, correct, or even erase their data. And a huge one for businesses is mandatory breach reporting. Any data breaches must be promptly reported to the Data Protection Board of India.
That immediate alignment with global standards is certainly crucial for, well, global competitiveness. Okay, now here's where it gets really interesting for you, our listener. Our sources for this deep dive actually break down compliance into 5 clear, actionable steps, things you can start taking today. It's kind of a roadmap to navigate this new landscape. So where do you even begin untangling this web of data? Our sources suggest the absolute bedrock is understanding what you're even working with. And that brings us to our first key area, getting your data mapped and maybe even conducting a data protection impact assessment, a DPIA.
Indeed. This is truly the foundational step. You can't protect what you don't know you have, right?
Makes sense.
So to effectively map your data, you need to identify precisely where personal data is collected, how it's stored, and who it's shared with. Think of it like creating a detailed blueprint of your data flow. There are tools, actually, like OneTrust or TrustArc, that can be incredibly helpful here. They can automate the discovery and classification part, which really streamlines things.
Automation helps.
Definitely. You also need to classify the data types, segregate the sensitive stuff like financial, health, biometric, children's data, and then conduct that DPIA, the Data Protection Impact Assessment. This means analyzing risks tied to high-impact processing, maybe processing health data for a new AI tool, for example. It helps identify vulnerabilities and figure out mitigation steps before they become, well, costly problems.
Right, proactive, not reactive. And that immediate audit readiness sounds like a huge plus. But with such critical tasks, it begs the question, who ultimately steers this ship? That brings us to our second area, establishing dedicated leadership, appointing a data protection officer or maybe a privacy lead.
Yes, this is a vital human element. The Act mandates that if your firm is designated an SDF, a significant data fiduciary, you must appoint a data protection officer. And that DPOPO needs to be based in India.
Ah, based in India. Okay.
If you're not an SBF, then a dedicated privacy lead should still be overseeing your compliance efforts. Their responsibilities are pretty broad: monitoring all data practices, ensuring DPDP compliance, acting as the main contact with the Data Protection Board of India, and crucially, managing grievance and breach processes.
So they're the point person for everything privacy.
Pretty much. They're like the central nervous system for your data privacy posture.
Our sources point out the value of setting up a data governance committee, too, to support the DPO and improve accountability across the board. That sounds like a brilliant move, actually.
It really is.
It distributes the burden and expertise, right?
Yeah.
Rather than putting it all on one person's shoulders.
Exactly. Spreads the responsibility and brings in diverse perspectives.
Okay, now on to our third area, which really gets to the heart of individual control: implementing robust consent management and clear privacy notices. When we talk about consent under DPDP, it sounds like a much more stringent requirement than maybe what many companies are used to. What's the biggest shift companies need to make in their mindset here?
You've hit on a critical point. The biggest shift is really from implied consent or assumed consent to explicit granular consent. Under the DPDP Act, consent has to be freely given, informed, and specific for each purpose.
Each purpose, wow.
Yes. This means companies need to use explicit opt-in mechanisms. Think checkboxes that are not pre-ticked, with very clear statements about why you're collecting the data for that specific reason.
No more hiding it in the fine print.
Exactly. And notably, privacy notices must be offered in India's 22 official languages, not just English. That's a big operational consideration for many firms.
22 languages, okay.
And you have to rigorously adhere to purpose limitation, collecting only what is truly necessary for that stated purpose. Now, to manage all this, deploying a consent management platform, a CMP, is highly recommended. It helps automate and track consent.
Right, the tech can help.
It can. And remember to maintain easy-to-access, updated privacy policies and use user-friendly cookie banners and preference centers that allow people to easily change their mind or withdraw consent.
So what's the tangible upside for companies that really nail consent management? Beyond just, avoiding penalties, what are the real gains?
Well, beyond the immediate compliance, it builds immense trust. When users feel genuinely in control of their data, that they understand what's happening, they're more likely to engage with your services, and that transparency really strengthens your brand reputation. It moves you from merely compliant to being seen as truly trustworthy in the eyes of your clients and customers.
That trust is invaluable. Which brings us neatly to our fourth area: upholding data principal rights and, importantly, preparing for the inevitable data breaches. What rights do individuals now have over their data, and what's the non-negotiable for breach preparedness?
Okay, so the Act empowers individuals with several key rights over their personal data. Companies absolutely must enable the right to access, letting users see the data you hold on them. They also need to facilitate correction and erasure, so users can easily edit or delete their information.
Makes sense.
Robust grievance redressal mechanisms are also essential. Fast, user-centric channels for resolving complaints or issues because, swift resolution builds confidence. And significantly, users must be able to withdraw consent just as easily as they gave it. No jumping through hoops.
Easy in, easy out.
Precisely. As for breach preparedness, well, it's a bit like a fire drill, isn't it?
Oh, yeah. Hope you never need it,
But you better know exactly what to do when the alarm goes off. Every company needs a clear breach notification plan with the defined timeline for reporting to the board and affected individuals. You need a system to log all processing activities that helps investigate breaches, and you really should run incident response drills regularly. Practice makes perfect, or at least less chaotic.
Absolutely. The cost of a chaotic breach response, both financially and reputationally, can be far worse than the breach itself.
Couldn't agree more.
Our sources mention using service desks for managing these rights requests and automated workflows for compliance tracking. That sounds like a huge help here, making it all much more manageable.
It really does. Leveraging technology for managing requests and documenting compliance is almost essential at scale.
Okay, finally, we're at our fifth and final area: conduct regular audits, train teams, and strengthen security controls. This isn't a one-and-done deal, is it? It sounds like a continuous process.
It absolutely is. Compliance isn't a project with an end date. It's a continuous journey. It deeply involves your systems, your people, and fundamentally your company culture. Your audit checklist should include things like regular internal data access reviews, who's accessing what and why. Getting third-party audit reports provides an objective view, which is valuable. And crucially, creating clear action plans based on those audit outcomes to show you're continuously improving.
Right, closing the loop.
Exactly. And employee education is paramount. Comprehensive onboarding sessions for new hires, sure, but also annual training on data privacy policies for everyone. Plus, maybe specialized workshops for tech and support teams who are really on the front lines handling data.
Makes sense. Targeted training.
And of course, robust security measures are fundamental. We're talking the basics, but they need to be solid. Data encryption, both at rest and in transit. Strict role-based access controls, or RBAC.
So people only see what they need to see.
Precisely. Multi-factor authentication, MFA, should be standard. And routine vulnerability scans and patching. It's basic security hygiene, but critical. And this aligns, as you might expect, with global standards like ISO 27001, which is another layer of confidence for clients, showing you're not just compliant with DPDP, but also adhering to global best practices.
So pulling it all together, what does this all mean for IT companies in Hyderabad? Beyond just, avoiding the penalties, how can they truly leverage this?
Yeah, this is where it gets really strategic. DPDP compliance can actually become a formidable business differentiator for Hyderabad's booming IT and SaaS industry. It's truly an opportunity, not just an obligation, if you approach it right.
How so?
Well, the strategic benefits are clear. First, you can win global clients because you meet those GDPR-like standards that overseas partners increasingly expect. It removes a barrier. But what's really fascinating is how some companies are using DPDP compliance, not just as a shield, but as a sword, a sales accelerator.
Interesting. How does that work?
Well, we heard of one firm, for example, that embedded their comprehensive DPDP audit reports directly into their initial pitch deck.
Really? Up front?
Yeah, they laid it all out. And apparently, it reduced the client's due diligence time by weeks. They ended up securing a major international contract, partly, maybe largely, on the back of that proactive compliance posture.
Wow, that's smart.
It really is. So it moves you beyond just faster contracting to actually building stronger brand equity through that enhanced trust and transparency in the market. Which raises an important question for listeners. How can you turn compliance into that kind of strategic asset?
Right.
You can actively promote your compliance readiness in sales pitches, in RFPs, even in investor meetings. It can accelerate procurement cycles, reduce that due diligence friction, and significantly boost both client and investor confidence.
Okay, you've just gotten a deep dive into the DPDP Act and how Hyderabad IT firms can navigate it effectively. It's definitely a challenging landscape, but ultimately it seems a rewarding journey if done right.
Absolutely.
Yeah.
And to briefly recap those 5 key areas we discussed. 1, data mapping and DPIA. Know your data. 2, appoint a DPO or privacy lead. Have clear ownership. 3, consent management and privacy notices. Be transparent and specific.
Right.
4, enable data principal rights and manage breaches. Empower users and be prepared. And 5, ongoing audits, training and security controls. Make it continuous.
Perfect summary. So here's a final thought for you to consider. If data privacy is truly becoming the new standard for trust and competitiveness globally, how might companies that lead in compliance not just follow, but lead the weed? How might they redefine not just their market position, but also the very nature of their client relationships in this digital age? It's a fascinating area to keep exploring. Thanks for joining us on the Deep Dive.